The Supreme Court has held that a daughter who attained a majority and is still unmarried is not entitled to claim maintenance from her father in proceeding under Section 125 Cr.P.C. if she is not suffering from any physical or mental abnormality injury. The bench headed by Justice Ashok Bhushan held that unmarried Hindu daughter can claim maintenance from her father till she is married, relying on the Section 23 of the Hindu Adoptions and Maintenance Act 1956. Provided she pleads and proves that she is unable to maintain herself, for enforcement of which right her application suit has to be under Section 20 of Act. The legislature never contemplated to burden the magistrate while exercising jurisdictions under Section 125 Cr.P.C. to determine the claims contemplated by the Hindu Adoptions and Maintenance Act 1956. The bench, also comprising Justice R. Subhash, Reddy and M.R. Shah, said the contentions of the appellant in this case was that as per Section 20 of the Hindu Adoptions and Maintenance Act 1956, a person has an obligation to maintain his daughter who is unmarried extends till she is married. The court held that the Hindu law prior to the enactment of Act 1956 always oblige a Hindu to maintain unmarried daughter who is unable to maintain herself. The obligation which is cast on the father to maintain his unmarried daughter can be enforced by her against her father if she is unable to maintain herself by enforcing her rights under Section 20. The bench also referred to Nur Sabah Khatun versus Muhammad Kazim and observed that effect of the beneficial legislations like Section 125 Cr.P.C. cannot be allowed to be defeated except through clear provisions of a statute. And now we are joined by Advocate Shivam Sharma to give us more update on this. Yes.
While comparing Section 125 of the CRPC with Section 23 of Hindu Adoption and Maintenance Act, the court noted that the former contemplates that claim of maintenance by a daughter who has attained majority is admissible only when by reason of any physical or mental abnormality or injury and she is unable to maintain herself. Further, the court held that a Hindu male was always held morally and legally liable to maintain his aged parents, a virtuous wife and infant child. While explaining the position under the Muslim law, the bench referred to the Supreme Court's previous decision in Nur Sabah Khatun versus Muhammad Qasim that the effect of beneficial legislation Section 125 the CRPC cannot be allowed to be defeated except through class provision of a statute. Therefore, the court dismissed the appeal with the liberty to the appellant to recourse Section 23 of the Act for claiming any maintenance against their father.